A. Background to making new law. How are laws made in the UK? A. Background to making new law. How are laws made in the UK? The predominant sources of law in the United Kingdom are primary legislation, known as Acts of Parliament or statutes, which begin life as drafts called bills, see B and C below; secondary or delegated legislation, such as statutory instruments, bylaws, and professional regulations. A new act is passed in order to update or amend existing legislation, legislate for new circumstances and enforce government policies. Ensure UK compliance with international or European Union (EU) law. Consolidate laws by bringing together into one statute all the existing statutes on one topic. Codify rules by bringing together all the statutory instruments, bylaws, and case law and statutes on a particular subject where the principles are established. Parliament can enact any law it chooses or repeal obsolete laws which are no longer relevant, and the courts must enforce it. The exception to this is EU law. Note: Act of Parliament and Bill are always capitalised in legal usage, statute is not. Statutory instruments are delegated legislation created by government ministers. Bylaws are made by local government or public bodies. B. Early development of a bill. The government may proceed to initiate a consultative process by the publication of a green paper in which its proposals are set out at an early stage with the intention of attracting public response and comment. The government's white papers contain their more definite proposals, although these are often published following consultation or discussion with pressure groups, professional bodies, or voluntary organisations. A bill does not have to be preceded by a white or green paper, although it may have been presented for public scrutiny, that is, examination, in draft form earlier. C. Passing an act. All acts must be submitted to both Houses of Parliament in the draft form of a bill. The legislative process involves 3 readings in both houses. At the first reading, the title is read to members of Parliament, MPs. At the second reading, MPs debate proposals. Then a standing committee will scrutinise the provisions in the bill and may amend it to ensure that it enshrines the principles debated and approved at the second reading. This is reported back to MPs. At the third reading, the bill is represented. The bill then goes through readings in the upper house. The actual drafting of the legislation is undertaken by Parliamentary Council. Finally, a bill must receive royal assent from the monarch before it becomes law on a specified date. In fact, this stage has been reduced to a formal reading of the short title of an act in both Houses of Parliament and is now a formality. Government bills are introduced by the government, private members' bills are proposed by MPs. Both methods may result in public acts that govern the general public. Private acts affect particular individuals or institutions.